Go ahead.
Madam Chair, Senator Olson. Again, I go back to my initial statement that the law in this area is unnecessarily complicated. Certain forfeitures require conviction of an offense, a designated offense. And obviously, in cases like that, if there are no charges that are brought, then no forfeiture could ever occur because you can't have a conviction until it's brought. But under the
Controlled substances.
Thank you. Controlled substances associated property, it's not a designated offense forfeiture. You don't even have to be charged. And in some cases, there's just a pending investigation and there are no charges. And a prosecutor under this statutory scheme would be free to delay charges up to 3 years under the Minnesota statute of limitations, while the other side of the ethical wall pursues a forfeiture proceeding and obtains discovery, including evidence that can later be used to prosecute and to obtain a conviction that might not otherwise have been obtained.
I'm going to change the order. I'm going to thank you for your testimony. We have actually...
Madam Chair and members of the committee, thank you for the opportunity to testify today. My name is Lee McGrath. I'm the Executive Director of the Institute for Justice, Minnesota chapter. The Institute for Justice is one of the nation's premier public interest law firms defending property rights. My firm is best known for representing Suzette Kelo in her defense of her property against eminent domain abuse in New London, Connecticut. After the Supreme Court decision in the Kelo case in 2005, my firm was instrumental in lobbying to see changes and seeing changes made in 43 states, including Minnesota. In addition to litigating condemnation cases and lobbying for eminent domain reform, the Institute for Justice has litigated civil asset forfeiture cases, lobbied for changes to state forfeiture laws, and submitted amicus briefs, including one in the forfeiture case currently before the United States Supreme Court, Alvarez v. Smith. The Institute for Justice is concerned about asset forfeiture laws because they allow for and sometimes even encourage the taking of private property. Just as in eminent domain, forfeiture laws empower the government officials to take property. But unlike condemnation, often little practical process is afforded property owners. The government can take property and have title passed to it without proving guilt of any crime. Moreover, unlike eminent domain takings, property owners face significant burdens to defend their properties, as you just heard, because of the cost and complexity of filing a lawsuit and other factors. My task today is a simple one. That is to give the committee some background information and history of forfeiture laws, and I promise to do it in all of about 4 minutes. Under laws at both the federal and state level, governments can forfeit property either criminally or civilly. Criminal forfeiture is tied to criminal conviction of an individual, where the government needs to show that an offender is guilty beyond reasonable doubt and the accused is afforded all rights under the Constitution. While criminal forfeiture can occasionally be abused, they are largely uncontroversial because the government must demonstrate in courts and juries must determine that the property owner obtained his property illegally before title of property shifts to the government. But civil forfeiture, on the other hand, is a legal creation. It's a fiction that enables law enforcement to take legal action against inanimate objects for participation in alleged criminal activity, regardless of whether the property is guilty or innocent, or even whether the property owner is charged with a crime. Civil forfeiture actions are in rem proceedings, which literally means against a thing. The property itself is charged, and that is why civil forfeiture proceedings have bizarre titles, such as United States versus $10,500 in U.S. currency, or State of New Jersey versus one 1990 Ford Thunderbird. And because they are civil proceeding, most constitutional protections afforded criminal defendants do not apply to property owners in civil forfeiture cases. And here is the history. The doctrine of in rem forfeiture arose from medieval ideas rooted in the ancient law of Diodan. Kings, for instance, could seize an instrument that caused the death of a person in order to finance the deceased funeral mass. The idea arose from a superstition that objects acted independently to cause death. American forfeiture laws arose from the British Navigation Acts of the mid-17th century. The acts were passed during England's vast expansion as a maritime power. The acts required imports and exports from England to be carried on British ships. If the acts were violated, the ships or their cargo on board could be seized and forfeited to the Crown, regardless of the guilt or innocence of the owner. The key point here is that the Crown often couldn't, and the English police could not get their hands on the suspect. So instead, in lieu of apprehending the suspect, they took the cargo and the ship. Using the British statutes as a model, the U.S. Congress, the first U.S. Congress, at the end of the 1700s, passed forfeiture statutes to aid in the collection of customs and duties, which provided 80 to 90% of finances for the federal government during this time. Civil forfeiture was introduced in American law through these early customs statutes. The forfeiture power was upheld in early Supreme Court cases. The most important aspects of these early forfeiture cases, however, is the very limited justification for the application of civil forfeiture to innocent property owners. The Supreme Court held that the civil forfeiture was closely tied to the practical necessities of enforcing admiralty, piracy, and customs law. In other words, in rem forfeitures permitted the court to obtain jurisdiction over property when it was virtually impossible to seek justice against property owners because they could not be found. Therefore, with civil forfeiture, the government could ensure that customs and other laws were enforced, even if the owner of the ship or the cargo was outside the court's jurisdiction. The United States Supreme Court Justice Joseph Story wrote that the vessel which commits the aggression is treated as the offender, as the guilty instrument or thing to which forfeiture attaches, without any reference whatsoever to the character or the conduct of the owner. However, Story justified such forfeitures, and I quote, from the necessity of the case as the only adequate means of suppressing the offense or the wrong. In other words, forfeiture laws were justified because law enforcement could not apprehend a suspect, but it could gain control over the property. Madam Chair, members of the committee, private property is one of the nation's most cherished principles, but it is a principle that is under assault. The changes to civil forfeiture that gave law enforcement agencies a percentage of forfeiture proceeds have created a powerful incentive to seize, to forfeit, and to profit. As dramatically seen in the Metro Gang strike force, these pecuniary interests have distorted law enforcement's priorities, altered officers' and prosecutors' behaviors, and most disturbingly, led to a number of abuses. By acknowledging the due process requirements limiting the power of law enforcement to act unilaterally, this committee will be taking the first step to curb those abuses and protect one of Minnesotans most fundamental rights. Thank you.
Questions?